Senate Judiciary is in session. Senator Reardon, you're going to lead me in the pledge. Thank you, ma'am. To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you very much, Senator Reardon. Motion to go into executive session?
Moved.
Yes. All in favor of the executive session, say aye. Aye.
Aye.
So we're going to go into 5:10 first. Senator, go ahead. Welcome to Senate Judiciary.
Motion to go into executive session.
I did that before, but okay. Didn't we already do that?
You did.
We did,
Okay.
but we're there. Doesn't have to be there twice.
Okay.
Senator Lang, I believe you have an amendment to 5:10.
Thank you, Mr. Chair. I'm Senator Tim Lang from Senate District 2. I apologize for my casual attire today. I had not planned on being in front of the committee. Yes, so you'll have House Bill 510, as you remember, is a bill about due process involving schools. This is a repeat bill that we had from last term. Last term it went to Senate Education. This term it was assigned to Judiciary. And we had interim studied it last term, hoping that the sponsor would go and work the university system. There were some problems that was in the bill and collective bargaining agreements and processes at the school. That didn't happen. We got the same exact bill refiled again. What this bill does is just turn into a study commission to allow the House members and the Senate members to actually meet with the university system and work towards an actual solution for this problem. And hopefully next term, bring forward a bill that is workable for both the legislature as well as the university system and the community college system. So I just ask you to adopt Amendment 671S, which just turns into a study commission, one senator, two House members, and members of the university system, members of the community college system, and with the goal of coming up with language for a bill that will work for next term.
Thank you very much. Do we have any questions from the committee? Seeing none, thank you for your testimony. No.
You have to move on to pass, and then you're going to offer the amendment. Yep.
So I'd like to move on to pass on 510,
Second.
and I would like to, all in favor?
No,
Aye.
Mr. Chairman,
Yes.
if I may speak.
Yep. Yes, thank you.
I think we need to offer the amendment first.
Okay.
And
And then the on to
take
pass
that for
motion.
consideration.
Okay. Okay, I would like to move amendment, I can't see it, 0671.
Second.
And it's the amendment Senator Lang just discussed.
And it's essentially a replace all that would turn this into a commission.
All in favor?
Aye.
Opposed? Okay, now I move the amendment. I move the bill with the amendment 0671 on to pass.
I'll second that motion.
Thank you. All in favor, say aye.
Aye.
Senator Abbas, you want to take it up?
Sure, I may move this for consent.
Yep, thank you. All in favor of the consent motion, thank you for the second. All in favor of the consent, say aye.
Aye.
Okay. And Senator Abbas will take it out. Thank you, Senator Abbas. Motion to come out of executive. Thank you. All in favor? Aye.
I'll
Okay.
second that.
Thank you. Okay, SB 464, Senator Abbas is going to make his way. Rick, could you grab me any glasses in my desk drawer? Thank you. Senator Abbas, welcome again, and if you could introduce 464 when you're ready.
Thank you, Mr. Chairman, members of the committee. I am Senator Darrell Abbas. I represent District 22, serving the communities of Pelham, Salem, Atkinson, and Plastow. and I am the prime sponsor here to introduce Senate Bill 464. I believe this makes I would say, a minor change to the law that actually would cover the original intent behind passing this in the first place. As the law is written today, it really just takes into consideration that the conduct in of itself is motivated by a protected class, race, religion, national origin, sexual orientation. It doesn't really factor in whether if there's any hostility towards the alleged victim here. And an example I can give you of how this law, as it's written, could be applied. If there was a sign that was on the wall that had a hate message on it, and someone were to take it down because they felt insulted by it, you can make an argument that they're violating the law as it's written. It's putting the prosecutor and the Attorney General's office in a position where they have to kind of pick and choose which ones are appropriate. I think the goal was of this, and I think the intent is that if their conduct is hostile towards the victim because of their protected class, that's what this is trying to capture. I think this clarifies it by writing it this way, as opposed to having what could potentially be inadvertent violations of the law, and you're going to have selective prosecution arguments. So I think this tightens up what the original intent was, and I would hope you support this and move on to pass.
Thank you, Senator. Just work with me a little on substantially. 2/3, 70%, 60%. How much is substantially?
So I don't think it's appropriate to assign an exact percentage to it. It has to be something that's really driving your conduct. If you accidentally run over someone's sign that has, whether it's a positive message or a negative message, your conduct's not substantially motivated by the hostility. You may have been speeding, driving recklessly, whatnot, but it had nothing. What the ultimate result was not motivated in any meaningful way by the person's race, religion, or whatever protective category the victim is apparently damaged by.
And so you don't think we're going to have problems with that being vague?
I do not. That
Okay.
term, that language is used quite often in other statutory contexts. I don't have a list of them all, but it is commonly used.
Good for me. No, thank you, Senator. Senator Reardon.
Thank you, Mr. Chair. I want to focus on the word hostility that you've added to the statute here. If I block somebody's access to someplace where they're entitled to be or something because of their race, gender, religion, any of those factors, but I do it in a really nice way, does that mean I can't be charged under the statute?
Thank you for the question. I don't think hostility has to do with how nice or polite you are about going about your business.
Mm-hmm.
I think the hostility is the conduct that is hostile towards that person's specific race or religion, their protected category, and that's what's really motivating you to do it, because it's just motivated by that hostility. So that's really the adverse conduct that you're engaging in. It has to be really the primary thing motivating you to do what you're doing.
Follow-up. So you're an attorney, you're in court trying to prove or disprove this. Isn't hostility and actions fairly easy to prove, and hostility towards somebody's thoughts about their intent about race or religion much more difficult?
Well, I think it depends on, you need a real specific fact pattern, right?
Yeah.
So let's say you had a poster on the wall that had a racial slur on it, and you walk up and rip it down. You're motivated, but you may be motivated by what it says, but you're not motivated by the person's race who hung it up. So what you're doing may be a hostile act per se to them, but you're not actually reacting to them because of their race. It's because you felt it's insulting. By the way, if it's a political sign of any degree, there's a separate law for that already that you can be charged with.
Yeah.
I'm just giving you an example where what you're doing is still technically illegal, but you could also be charged under this simply because it may be motivated in any meaningful way because of their race, but it's not, there's no hostility towards that person because of their race.
One more follow-up.
Yes,
please.
follow-up.
Thank you. So has there been a lot of trouble in legal cases here where they've had trouble charging that or or you've been offended by somebody being charged with that, that's brought this about, or
There's been legal
did
cases.
prosecutors ask you to bring this?
No, no. I get asked to file a lot of bills, and I often don't comply with the requests. I have to really actually personally have some belief in it. I just look at this as this was something that we discussed as a legislator in the past. The whole idea was if the bad actor is acting adverse to you and then motivated because of your race, because of your religion, because of that protected class, that's what's driving their behavior. This, as it's written, it's not really necessarily has to do with them having any anger or hostility towards you whatsoever, any type of prejudice. It just happens to be related to the conduct. Maybe it could be interpreted that way, but during all the discussions, I think this captures what we initially discussed better, makes a good law better, and it should be clear, because I don't think someone should be simply charged or be found in violation of this simply because they saw something that was expressly offensive directed towards their protected class and they reacted, because whoever put that there, that person's race or religion is not really on the table right now.
Mr. Chairman, one more, last one. Thank you. So the existing language is when any person by actual or threatened damage to or trespass on property when such actual or threatened conduct is motivated by race, color, religion, national origin, ancestry, sexual orientation, sex, gender, going on. That's not adequate to prove what you're talking about there. You need like an extra, like an enhanced.
Well, I think you're not understanding my
No.
response. What I'm trying to say is I don't want that person to fall under this because I don't think their conduct was intended to fall in this, because they're on the receiving end of seeing a hate message, and because they react to it, you can still make an argument that they fall under this. But I don't think that was the intent of what the law was when we passed it.
So that's up to a prosecutor, a judge, a jury to make that determination.
Well, the judge and jury, they're the fact finder. They would make the finding of fact. It's the prosecutorial discretion of the county attorney in Attorney General's office if they see a case and say, oh, well, we see this. But I think when you have laws, you don't really want that to be a selective prosecution type of thing, especially on something as serious as a topic of this. I think this just tightens up what is already a good law, but it makes it much clearer what the original intent was.
Senator Oshler.
Thank you, Mr. Chair. Thank you, Senator Abbas, for taking my question. I'm a little worried that adding in the substantially motivated by hostility toward the victims and then insert all the things there creates a window where you can threaten violence or damage to someone, but I don't really mean it. That's not what I meant. I'm not racist. I'm certainly not anti-Semitic because I'm not substantially motivated. So I think I'm wondering, what's the bar? Like, how do we get from a threat against someone based on their race, color, religion, national origin, ancestry, sexual orientation, sex, gender identity, or disability to what is a substantial threat? So is there like an unsubstantial threat that's just kind of okay to harass people?
Yeah,
or
no, I appreciate the question, and that's an excellent question, because you're trying to figure out, do they actually fall under this? And that's one of the key elements to this in the first place. So let's look at it this way. I'm of Middle Eastern descent. If someone were to simply yell at me and say something to me that was rude, saying, oh, we don't think you're a good son, is not going to fall into here. If someone makes a racial slur to me or an anti-Semitic slur to you, it's very clear what that person's doing when they say it because of the meaning of what they say. I think you'll know it when you see it. They wouldn't make a racial slur or any derogatory term like that if that wasn't their motivation. So it will fall under pretty quickly. But also, it's not just the simple act of saying it's you're directing it at and targeting a victim with it. And victim here is spelled out very clearly. You would need to have something like that. Obviously, it involves the threat or perceived threat of violence as well. But those all go, I think when you have it, you have to prove that. And that's just to fall into this. I look at it as it has to be very clear what you're motivating, you're targeting a victim. And if you're throwing in that language with it, I think it's very clear what's motivating that. I mean, it's hateful speech. Clearly, it's pretty clear to tell in those circumstances what's driving them and motivating them to do what they're doing.
Well,
No, thank you.
thank you. Yes, Attorney Lehman.
I think it's helpful towards questions about substantially and hostilities that this language now is exactly the same language that's in the criminal hate crime statute. So it just repeats what's already been the law in the criminal context in New Hampshire for a long time. This is a civil statute, but it uses an existing standard.
Thank you very much. Thank you, Senator Abbas.
Thank you.
Steve Bozendowski? Okay. Thank you for coming in today.
Good afternoon. My name is Steve Bozanowski, and I am an active member of the Congregational Church of Amherst, which is affiliated with the United Church of Christ. I've been an active Christian for my entire life. I don't wear it on my sleeve, I don't proselytize, but it's an important part of my life. It helps me define the man that I am. I've belonged to a few different churches in the course of my life, but I particularly love the church, my current church, and what it stands for. Here's how we describe our church. We are a loving, serving, open and affirming community of faith. In an age when organized religion is often perceived to be narrow-minded and exclusive, we offer an alternative way of being church in the world, where God is all-loving and inclusive, where the community of Christ welcomes and accepts everyone as they are, with no exceptions. Our welcome statement reads in part, we welcome each individual as a child of God. We celebrate God's love for people of all races and ethnic backgrounds, all mental and physical abilities, all socioeconomic backgrounds, all sexual orientations, all gender identities and gender expressions, and all the other diverse attributes woven into the fabric of humankind. This extravagant welcome is important to our church. We feel it defines us, and we work hard to make it known that we welcome people who have been traditionally felt unwelcome in other churches. Recently, we got a new sign for the front of our church. It's a beautiful sign and a source of pride for our congregation. At the bottom of the sign on a rainbow field are the words, welcoming to all. We have heard of other churches being attacked for similar messages of inclusion, but we will not be deterred in our mission. We also feel somewhat protected by the current New Hampshire law. But if SB 464 is passed and the current law is weakened, I feel our church will be more vulnerable to the criminal element fueled by hate. I feel this is a freedom of religion issue. Senators, I beseech you to vote no on Senate Bill 464. Thank you very much.
Any questions? Yes, Senator Oshel. I'm sorry if you'll take questions, sir. Thank you.
Yeah. Thank you, Chairman. And thank you, Mr. Bozanowski, for taking my question. So is it the opinion of your church that this proposal weakens the current law? And have you had experiences where there have been attacks on your signs or your displays or anything like that?
We haven't had that experience. Well, we do feel that this weakens the law and it'll make us more vulnerable. We haven't had that experience ourselves. But this is kind of the new sign, so it has the rainbow in the front. And we're familiar with other churches of our denomination who have had that experience. And we're ramping up in that eventuality that might happen. We're considering adding cameras to the front of the church and that sort of thing. But in 2026, this is a reality of our living.
Thank you.
Everyone else set? Any questions, Heather? Seeing none, thank you for your testimony today. Sean Locke. Afternoon, Attorney Locke.
Good afternoon. I appreciate the sign here. To remind me that the red light needs to be on. Mr. Chair and members of the Senate Judiciary Committee, good afternoon. I am Senior Assistant Attorney General Sean Locke. I direct our Civil Rights Unit at the New Hampshire Department of Justice, and I am here on behalf of the department to oppose Senate Bill 464. I think the concern we have is that 464 takes us in the wrong direction because it's reducing, the Civil Rights Act already covers a limited set of circumstances, and we're reducing the protections that are afforded to the public to protect their civil rights from hate or bias motivated violence, property damage, threats, and trespass. Instead, we should be looking for ways to expand or modernize the civil rights laws like RSA 354B to better protect those who have experienced unlawful acts motivated by hate or bias. But I'll come back to kind of how to expand and how to kind of modernize later. I think, I want to kind of focus on some of the points that came up during Senator Abbas's comments. Specifically, I'll start with kind of the ideas of hostility and the substantial language. Hostility is probably, of the three changes that we think this bill makes, hostility is probably the least concerning of the three. Generally, when we're looking at these acts, because we're the only office in the state that can bring these actions, when we look at them, we're looking for that evidence of bias, hostility, or animus behind there. Even though it's not written in the statute, that is what we're looking for. And if the language were included, I would share some of the concerns expressed by Senator Reardon of hostility sometimes conjures in someone's mind more than maybe what is intended here, but I would probably be making the same arguments that Senator Abbas made in response to that question, in the sense of the hostility is kind of apparent from the adverse actions that someone had taken. That's why it's probably, of the three changes, the least concerning. But I would say that in terms of looking at similar laws in other states, not all of them have that animus or hostility requirement. Many of them use similar language to what the Civil Rights Act does. Motivated by, motivated in whole or in part by, because of. Some states, especially in their criminal laws, less so in the civil analogs, will use discriminatory victim selection. So the person was selected because of their protected characteristics for the act. The civil laws generally are a little broader, looking at the states that have those, which there are about 28 of them. In terms of substantially, the concern here, and it's my concern anytime I see adverbs or adjectives popping up in legislation, is that it does create a risk of vagueness, and I can kind of point to a real circumstance where this actually became the linchpin of a criminal case. This was in Hills North, so Manchester. There was a same-sex couple who were walking down Elm Street together. It was kind of after they had been out for the evening, I think at Murphy's Pub. They were walking back, they were showing affection towards each other. They were followed by two individuals, or I think a group of individuals, calling them slurs, making kind of homophobic comments directed at them. They turned peacefully, didn't try to start a fight or anything, but turned to say, basically, leave us alone, and they were assaulted. That went to trial. It was a bench trial, and the judge in that case acquitted the individuals of the hate crime because of that substantially language. Didn't know what quantum of motivation needed to be present to secure a conviction. That substantial language is relatively unique. It's not very common to say substantially in other hate crime laws in other states that I've looked at. So like I said, a lot will use just either motivated by, using that in whole or in part language. Again, some might use discriminatory victim selection in the criminal laws. In the civil laws, those are generally lacking, and that's kind of the concern here with including substantially. It creates a question of what quantum of evidence needs to be present, which could create disparities across different courts as different judges rule on these cases before there might be a disposition by the New Hampshire Supreme Court. The major piece that I want to talk about here is this kind of and what I think is the most significant change is that the statute creates kind of what I call in my notes a through line between the unlawful act and the victim and their protected characteristics. And so when we look at the two laws in New Hampshire that kind of govern kind of bias, kind of motivated acts, 354B and the sentencing enhancement 651-6, paragraph 1F. 651-6 says that the person was substantially motivated to commit the crime because of hostility towards the victim's protected characteristics. So there's a through line there between the crime, the motivation, and the victim's protected characteristics. The Civil Rights Act, on the other hand, says, basically has three elements. There's an interference with rights or lawful activities of another, using certain specific unlawful acts, uses of force, violence, property damage, trespass, or threats, that are motivated by, and they are motivated to do those unlawful acts by protected characteristics. It's not tied to necessarily the victim of the unlawful act. And I think that lack of a through line one is not unique to New Hampshire, that many states that have civil components to their hate crime law also lack that same through line. And they have that for a few reasons. One, a person, I kind of think of this in terms of, there's historical examples I'd give, a contemporary example, and kind of a hypothetical where this could come into play. Historically, if you think of the civil rights movement during the 50s, 60s, you had freedom riders, you had individuals many of whom were white, going to the South to kind of advocate for the rights of people of color, Black people specifically. They were victims of threats, they were victims of violence, some were killed because of hostility towards the race of Black people as a race. This law, the way it's written now, without that nexus between the victim and the motivation, would protect their civil rights, protect them from that race-motivated violence. It would allow us to seek a restraining order to protect them from that harm. We've seen that play out here in New Hampshire at the Laconia State School property. It's a location, I know it's been sold, so I don't know what its current status is, but for years it was abandoned, and there have been trails, walking trails, hiking trails built throughout the property. But the old buildings were still there, and individuals affiliated with hate groups would use that to spray paint swastikas, Nazi symbols, tag for their hate groups, and cause kind of fear in the community about what's going on, who's doing this. But it wasn't necessarily targeting a specific person. It wasn't naming specific people. It was causing fear and terror through property damage that affected the rights and kind of freedoms of not just the Jewish community. The Nazis targeted many individuals, but specifically the largest number of concerns were raised by the Jewish community about these acts. Again, having that, does the property owner have to be Jewish now if they're being targeted with this type of property damage? The hypothetical that comes to mind where this could also play out is you think of a neighborhood. Person owns a house, they fly a pride flag, and the neighbors across the street, someone wanting to kind of target them and instill fear in them, vandalizes the home across the street so they see it. They're kind of the indirect target of this act of violence, this act of property damage. And again, their civil rights are the ones that are at stake as opposed to, and maybe it includes the individuals who are the direct victims of the attack or the incident. But, that's the concern here, is that there are other ways that people's civil rights can be violated rather than just being the immediate victim of the act. And so to kind of diminish that reduces the flexibility you have. And this is a statute, I say it's a civil statute because I think that's important. It's a prospective remedy. We're looking to restrain future unlawful conduct. No one's going to prison for violating the Civil Rights Act. They're getting a restraining order that says, don't engage in this behavior again. Don't engage in other hate-motivated conduct. Don't have contact with the victims of your act to protect the public from future harm. That's where I think some of the rigidity that we need and the specificity we need in criminal law isn't as necessary when we're talking about civil statutes. In preparing for this, I looked at the states that have similar civil laws. There are 28 of them across the country, or about 28. Of those 28, 17 lack that victim kind of act or the protected characteristic nexus that I just talked about, or that through line. 10 do require that, but 3 of those include in their list of protected characteristics targeting someone because of their association or affiliation with people of certain protected characteristics. So you could still maybe capture those groups where someone's being targeted indirectly or targeted for kind of being supportive of particular groups or advocating on their behalf. The remaining 7 are kind of civil rights of action where they largely directly they basically say if you've experienced a violation of our hate crime law, you're entitled to these kind of enhanced, usually civil remedies. So enhanced damages, attorney's fees and costs, things that wouldn't normally be common in a normal tort claim. So that's kind of the concern that we see in terms of adding some of these terms. Like I said, there are others where there's the hostility piece is probably the lowest of our concerns, the nexus kind of component is the highest, and the substantially is probably somewhere in the middle. At the beginning, I talked about kind of taking this and looking at ways to kind of enhance our civil rights laws, and I'll kind of try to be brief on it because I know I've exercised a lot of time here. But there are tools out there. There's recommendations from organizations like the Anti-Defamation League about how to enhance our laws. Whether creates a hate crimes commission that could get together and look at these laws and see what changes could be made, including our discrimination laws, including the Civil Rights Act, including hate crimes. How can we enhance that? How can we create more resources and tools for communities, for schools, for anyone who needs them to combat hate as it appears in their communities? Another example, New Hampshire is one of 7 states that doesn't have a law that protects religious institutions specifically. So that's a tool that's available to kind of maybe enhance the protections that we have for our diverse communities across the state. But the last one, thinking about the Civil Rights Act, one of our more common complaints that we receive is harassment. It's people receiving communications that are targeting them because of who they are. Harassment isn't included in the Civil Rights Act. We have no ability to take up those cases. And they are being called, like some of these folks are being called some of the most horrific slurs and terms that you can imagine. We kind of have to point them to law enforcement and hope that there's wherewithal to pursue harassment charges. So this, including something like that, would help us enhance our ability to protect these individuals. Remembering that this law was first passed in 1999, we communicate very differently now than we did 27 years ago. And so these kind of tools and these steps could improve the protections for people in the state. As currently written, we'd recommend that this bill be deemed inexpedient to legislate, but we invite kind of conversation about ways to improve it or improve our laws in general. I'm happy to take any questions.
Senator Abbas.
Thank you, Mr. Chairman. Thank you for taking my question. You said that when these cases are taken up by your office, you're generally looking for hostility. If that's the case, what is the problem with adding that to the law?
That's why I said it's the least of my concerns. I think the word itself engenders a certain kind of vision of what that is, but it's not, I've been racking my brain for a better term to use, and I haven't come up with one yet.
You said it's the least of your concerns, but why is it a concern at all if that's exactly what you're looking for?
It's a concern because, again, it creates a certain definition in people's minds. It could create disparity in how these cases get litigated or what outcomes people expect depending on who's making those decisions. That's I'd be willing to try to think more about a better term to use, but like I said, it's not so much that we aren't looking for it. It's an issue of if that becomes an element that has to be proven, what that actually has to look like to convince the variety of judges and juries that these cases may be brought before.
Oh, yes. And I'll give you a hypothetical. If for some reason someone's upset with a person, another man, and then they actually hit the wrong man, they get confused, whatever. Again, other illegal acts occurring there, but their conduct's motivated by that person's sex because it's a man. They would fall under this simply because it's motivated by that. Not that there's any hostility per se or any prejudice that they have against the victim because of their sex. Because their behavior is motivated by it, they would technically fall into this. I'm not saying your office would take this up because you probably wouldn't perceive there being any hostility there. But I look at this as at least my attempt is, it would remedy that where people may fall under this when I don't believe it was the intention of the law as written for them to fall under it. That's what I'm going for. Now, if you can help me get there,
And I'd be happy to help you try to get there. Like I said, I'm not, that's the piece, like I said, of our least concern. I just want to make sure we have maybe a good term that could capture the different forms of adverse conduct that could occur that might be motivated by someone's protected characteristics as opposed to things that are happenstance. I mean, the same issue can come up. You could arguably say any sexual assault could be a civil rights violation because usually an individual is being chosen because of their sex or gender. So I agree that's why we have our own limiting principle on how we look at these, but be willing to work with you to find a solution.
but why not put that principle into the law itself? I'm just saying, because I understand that maybe your office right now in present time is applying it correctly, but 20, 30 years from now, who knows? I just look at it as, I don't think we're changing type of cases your office would handle or prosecute. I think what we're doing is kind of capturing what you're doing anyway, but shoring up with what's on the books.
And I would just want to make sure we're using language that isn't over-inclusive or under-inclusive in making that determination. That would be my concern. I worry, maybe there isn't a better word than hostility out there, but I would worry that I would like to find something that kind of captures what you're trying to do.
Go ahead.
Without kind of under-including situations that would be appropriate.
And thank you,
Yep.
thank you, Mr. Chairman. And I totally agree. I would not want to under-include someone. That's not the intention I have with this. But could you give maybe perhaps a hypothetically you can think of where someone might be under-included? I'm just curious if you can.
So I can think of a scenario like, again, if you're thinking of hostility, use the hypothetical of someone's blocking someone's access to, or interfering with their ability to kind of access house of worship. Someone's blocking the entrance there. Again, it might be adverse. They may not want people to go in there. They might want to be trying to obstruct the worship that's going on there. But they may not be making kind of derogatory comments. They may not be doing things in a way that would kind of suggest kind of overt hostility, even though they might have that motivation to prevent this person from being able to exercise their rights. And so if using the word hostility requires kind of, or creates kind of in a fact finder's mind this expectation that someone has to be shouting slurs, someone has to be doing something kind of overtly kind of racist or homophobic or kind of anti whatever the religion may be, that's where you might create under-inclusion.
Thank you.
Other questions? Yes, Senator Alsler.
Thank you, Mr. Chair. Thank you, Attorney Locke, for taking my question. In your description of a couple of different scenarios, I can't stop turning around the one about an LGBTQ couple and this house across the street
Yes.
being targeted as a way to message. And thinking about that indirect way of getting a message across, does this proposal create plausible deniability for creating stochastic terrorism in a community?
So I think, that's always something that could exist regardless of whether this is the law or another thing is law. Someone can say, I didn't know I was targeting, this, or they weren't my intended target. That can always come up. But I think, that's kind of where the case-specific nature of some of these scenarios come up. But I could give you an example as well that actually is a real example we dealt with. It was a couple who were putting up a pride flag on their property, and an individual who believed that, would think children walking to school would walk by and see the pride flag, didn't think kids should be exposed to that, was going onto their property at night and tearing it down and disposing of it. They were a same-sex couple, but he didn't know that. And so, again, kind of having that link, that requirement there, if we have to show that this person knew he was targeting someone because of their characteristics, as opposed to being motivated by hostility towards LGBTQ plus people generally, that makes it a little more challenging to kind of bring those types of cases and afford those protections for those individuals.
All set. Thank you very much for
Thank you
your
all.
testimony. Does anyone else wish to testify on SB 464 who didn't sign in, or seeing none, that'll end the hearing. You can't use 619. Sarah. We'll start the hearing on 619. Senator Abbas, welcome.
Thank you, Mr. Chairman, members of the committee. I am Senator Darrell Abbas. I represent District 22, and I'm the prime sponsor of SB 619. And I'm here to introduce the bill. Just a quick overview of this. This was kind of put with a collaboration of several different interest groups, and I believe a lot of them are here to speak on this. There is a proposed amendment as well that makes some minor housekeeping changes to it. I don't want to bore you too much with this, but basically what is happening here, it creates a clear procedure when if you had an animal confiscated. It kind of wraps up the time period very clear and concise. You don't want to leave those open-ended. They can get expensive. I don't think there's any procedural gaps here anymore, any pauses. I think this covers that ultimate problems what the goal of this was. And it's dealing with animal cruelty cases specifically. And I'll be happy to answer any questions.
Thank you. No,
I had a copy of that amendment in my paperwork, and it's just,
is it 0674?
it's somewhere.
0674, is that the amendment? I believe I have it.
Yeah.
Because I have a binder, all people follow my example and have a binder.
And I had it when I walked in the room, so it's in here somewhere.
Okay, no, I have it, but we haven't examined it well. You're welcome. I'm sorry, Senator Elsley. Yes, you may.
No worries.
Okay.
No, my question is unrelated to that,
And
unless
I assure
my
you,
question.
Senator, it is probably at the desk to your left, and I will find it to you when I return to
Okay.
my destination.
Thank you, Mr. Chair. Thank you, Senator Abbas, for taking my question. This is a lot of prescriptive language. And what happened? That something has to happen that we now have to put out all of these prescriptive pieces of information within a statute because obviously it wasn't happening before. So what was the incident what sparked this?
What sparked
Yeah,
this?
just so I can wrap my head around all
I
of this.
actually, I can't list a exact incident. I really put this in collaboration with law enforcement and the Humane Society. I agreed to file it after meeting with them discussing the bill. So was there a specific incident that led to this coming together? I wouldn't be able to speak on that. I didn't ask. If I think it's a good policy, how many problems are we solving when by passing legislation? I look at it's a good policy. It's worth the squeeze.
Oh,
Yep, follow up. Yes, ma'am.
I'm sorry. You said the Humane Society and law enforcement were asking for this, for some clarity?
I don't want to say that they're asking for it, but
Okay.
this was done in collaboration and talking together. And if I obviously didn't believe in the policy, I wouldn't file it.
So, but they participated in the writing, so this has stakeholder support is what I'm asking, I guess.
Depends on who the stakeholder is, but yes,
Oh, okay.
I believe that this would have their blessing. And I know the amendment was done with the same intent. However, the law enforcement officer I was collaborating with is on vacation, so I'm not clear that he actually was able to read the amendment yet.
Senator Carson.
Thank you, Mr. Chairman. Good afternoon, Senator. The way that I'm looking at this, it just, we've had these instances where multiple animals have been confiscated because of, not very healthy living conditions for them, or they've been abused or neglected. And usually when that happens, the shelter that they're taking to they go out and they ask for donations because they can very easily be overwhelmed for the care of the animal, whether it's they haven't been fed correctly or they might need to see a veterinarian. And I think anybody who has animals know how expensive it can be to take an animal to the veterinarian. So the way that I'm looking at this is by charging the, not to exceed $1,000 for each animal is to offset that cost. Because, we like to think that shelters operate for free, but the reality of the situation is they do not. Oftentimes they subsist on donations, people, bringing food or, a veterinarian will donate their time. But if you have an animal that comes in with a complicated medical case, which can just simply from neglect that the animal wasn't being fed. You just simply can't put a bowl of food in front of them and say, go ahead and eat, because there are some health implications that can happen. So am I reading this wrong? That would be the purpose of some sort of charge to the person whose animal it was that they had to take?
Well, yes, but indirectly would address that. What happens is if someone's charged with this and their animal's confiscated, they're posting a bond to basically avoid that animal being taken away from them and disposed of. Like, think of a civil forfeiture proceeding. Now, anyone can, without the bond, anyone can tie that up. And if the person does that, then the animal would have to be stored somewhere until it's determined by the court. So by having this $1,000 bond, it would then solve the issue that you just raised.
Okay.
However, it's paid into the court, and I believe the court would then have to address that at a later date.
May I follow up, Mr. Chairman?
Yes.
Thank you, Senator. I'm looking at the amendment, which I now have a copy of. It looks like what the amendment did, it removed lines 21, 22, 23, and then, which was section C, and just renumbered sections D to be C. Am I correct?
I certainly hope so. I don't have it in front of me,
Oh, okay.
but it sounds correct.
Yeah, okay. I just wanted to be sure. Thank you very much, Mr.
Senator.
Chairman.
Yes.
Thank you, Mr. Chair. Thank you, Senator, for taking my question. So back to the bond. When you place a bond, it's to ensure performance. That's what bonds are about. And if you don't perform, somebody gets to liquidate the bond. I don't get in this scenario here who ends up with a bond. You place a bond just to say, I'm going to show up at court, I am going to defend my right to this animal, or is the bond liquidated, as Senator Carson proposes, to cover the costs of the person that's holding the animal?
First, I think it would depend on the outcome of the case. I wouldn't be able to answer that in its entirely, like procedurally. I would have to look into that further to give you the best possible answer to that.
Oh, thanks.
Thank you, Senator.
I was going to request we not exec anything today because as I said, the law enforcement officer that I was in conversation with is hopefully enjoying a vacation right now.
Thank you very much for your testimony, Senator. I think we're all set, right? Oh, I'm sorry, Senator Officer, sure.
Thank you. And looking at the amendment and about if the accused fails to appear in court, which I think is D in the original. And I don't see any change in the language between the amendment and the original, but it says if the accused fails to appear in court without giving prior notice within 3 days of the hearing date, or if less than 3 days notice without evidence of emergent circumstances, how do we, there may be something else somewhere else that addresses this, but how do we make sure that someone doesn't just keep doing that over and over and over again, 3 days, 3 days, 3 days?
Well, first of all, that does happen. We're
Yeah,
tactfully doing things to delay proceedings. It's up to the court. The court would have to approve any, if they're going to reschedule something, it has to be approved.
Okay.
And if you have a good cause, a good reason to do it, very rare that continuance is not permitted. If there's any belief that it's done with any, wrongful tactics, most of those, none of those really make it by.
thanks.
Thank you very much, Senator Abbas.
Thank you.
Patricia, it's either Norris or Morris. Go either way. Good afternoon.
My name is Patricia Morris. I am a 20-year resident of Barnstead, New Hampshire. I've been a 50-year resident of New Hampshire. I want to thank you all and sponsor Abbas for bringing this bill to the table. I can give some answers to some of the questions you just asked. I practiced animal law in the tri-state area for 20 years. I teach animal law at the University of New Hampshire School of Law. I've sat for 18 years in the Governor's Commission for the Humane Treatment of Animals, 13 years of which I chaired it. And what that group is made up of about 25 stakeholders, from Senator Waters to a House representative, including the Chief of Police Association, the Sheriff's Association, the State Veterinarian, the Veterinarian Society, humane organizations, and a number of others. I'm here in two ways today. One, to comment for the Governor's Commission on the Humane Treatment of Animals and their position on the bill, and then also personally. So this morning, the Governor's Commission on the Humane Treatment of Animals met in the Governor's office to discuss this bill as written. And as written, it opposes the bill for some specific language concerns. But the amendment, of which I worked very closely with the law enforcement officer that worked for Senator Abbas and some of the other stakeholders, addresses all of those. So if the amendment that we saw informally is the amendment that's being put forth here today, then the Governor's Commission on the Humane Treatment of Animals supports that this ought to pass. Personally, any questions for the Governor's Commission before I move on to myself personally?
Being none.
Personally, I am of the same position. As written, I would have to oppose the bill as written, but with the amendment, I very much support this. As I mentioned, I do practice animal law. I have represented both sides of animal cruelty, the defendant and the prosecution. This bill came about because when we have trial, there's usually a title for a hearing. It's an arraignment, it's a bail hearing, it's a motion to strike evidence. This was just a hearing, and we were going before the courts, and they didn't understand what their authority was or what was supposed to happen. And animal cruelty, as Senator Abbas mentioned, is very unique as far as the evidence is concerned. You can't stash it in an evidence locker. You can't put it in a parking garage while you're waiting for trial. The animal has to be cared for, and those costs can skyrocket. And those costs, believe it or not, fall onto the town and the taxpayers if there's no conviction. So this was much needed to help the courts understand what they could and could not do. So mainly what this bill does is it says that after it is confirmed that the confiscation was lawful, meaning probable cause, it allows the court to consider any issues specific to this case brought up by either party, the defense or the accused. It can be custody, it could be a veterinary examination. The defense or the defendant or the accused does have a right to have a veterinarian of their choosing examine the animals. It could be visitation, to schedule trial, more hearings. It could start plea conferencing. It gives the court a wide latitude of what it can do. Specific to the bill in front of us, what we were concerned with, and I haven't seen the amendment as before you, is that specifically it talks about the court's ability to transfer the defendant's interest in its property. That just can't happen. Until there is a conviction and the appeal period has passed, the court doesn't have the authority to transfer ownership, but it can determine custody. So the language, I believe in A, that's changed is it says that the court may transfer the custody of the animal to the remaining owner. I believe that's in the, okay. And then it also says the court, the last line in A should say that the court may also address any other matters before it. Section B, this is something that can be heard of at the hearing as well. If there is a bond, this is permissive. So it is not mandatory, depending on the cases of the facts before the case. And then in C, we did strike that. Oh, this is wonderful. Thank you. C has been struck, which is wonderful. And the difference in C, and I know which was the old D, is that initially the language said failure of the owner to appear. That needs to be the accused. The owner is not necessarily the person who is going to be accused. Fails to appear in court, and this is also because this would happen. The defense would not appear, and this would continue leaving the prosecution, leaving the animals all in limbo, and it would continue. So what this says is, we already know there's been probable cause to seize your animals, so you've had that step taken. Here, the court can then say, if you're not showing up in order to discuss this and what we're going to be doing, the court may, it's not mandatory, may make a ruling on those motions if the defendant does not appear. And that way they can say, yes, we're not going to wait for another 30 days, whether you appear or not, to say these animals can go into the custody of the co-owner, which is in the best interest of the animal, for example. So that's just quickly my testimony. But as this is the amendment that I worked on, and both the commission and myself would strongly urge that you all ought to pass.
Thank you for your work. Questions? Nope. Yes, Senator Redden.
Thank you, Mr. Chair. Thank you for taking my question. Just talk to me about the bond a little bit. The questions I had asked Senator Abbas before. what happens to I see that it's returned if somebody's found not guilty, but I don't see in here any right of anybody to get the proceeds of the bond,
I think there could be some fine tuning in the language. There already is a bond requirement in 644-8, which is the animal cruelty statute.
Yep.
If there's an appeal, but it's not at the time of confiscation. And so it's my understanding with the bonds here that if there is no finding of guilty, that the bond would be returned. And if there is a finding of guilty, it would go towards offsetting the cost of care. But I would also hope the court would have the leeway that if there is an animal who has been confiscated that needs life-threatening surgery or whatnot, and the owner agrees to that or the veterinarian testifies as to that, that bond could be ordered to go towards that as well.
Thank you. Can I follow up?
Yep.
That is clarifying, and that's helpful. I think if we put cost of care or whatever, in there, that would be helpful. And I remember having one of these cases last year. Is it wise to possibly, instead of saying $1,000 or as the court may determine, because sometimes it's an injured animal that's really expensive to rehabilitate.
I think that the concern was most of the time we're seeing large animals, large number of animals being seized, and they were trying to do a cap on it, so it seemed. But yes, there's been a lot of conversation about can that be within the discretion of the court. And I think from what I can understand, some stakeholders were concerned that it could become too much, especially if you have the first $1,000 due upon confiscation, and then you're going to trial and you appeal, then you can have up to another $2,000 on top of it for each animal.
Very good. Thank you for your testimony.
Thank you.
Does anyone else wish to testify on SB 619? Come on down. Are you Lisa? Okay. Get you. Hit that little red light first. Yep, and just
Oh, there
say
it
your
is.
name and who you are. Be great. Thanks.
Good afternoon. Thank you for having me here today. Chairman Gannon and Senator Abbas, of course, and the rest of the committee. Thank you very much. My name is Lisa Dennison. I'm the president and CEO of the New Hampshire SPCA. I'm also a past president of the New Hampshire Federation of Humane Organizations and a current advisor. And I'm speaking today on behalf of the New Hampshire Federation of Humane Organizations. I'm here to offer our support for Senate Bill 619 as amended. Important legislation that addresses the complicated intersection of animal welfare and judicial efficiency. Senate Bill 619 revisits the 14-day status hearing established in 2019 following the Great Dane case and, for us, the German Shepherd case, both of which took nearly 2 years to resolve and was over 100 animals before the criminal proceedings unfolded. During that time, the animals struggled to maintain their behavioral health in the prolonged shelter environment, while massive costs accrued. These cases, along with many others across the state, demonstrated the urgent need for clearer direction for consistency for the courts. Delays that go on for months and sometimes even years place a substantial financial burden on the state's cost of care fund and also the agencies, and in turn may impose debilitating costs on defendants, and most importantly, hurts the physical and behavioral health of the animals involved. The original legislative intent of the 14-day hearing was to streamline animal confiscation state cases by creating a priority timeline and a clear financial mechanism to ensure proper care. And I think Trish spoke to some of that. Senate Bill 619 provides a much-needed procedural guidance for the courts to hold the hearings and address time-sensitive animal care issues as originally intended. It clarifies that the court has the discretion to require a defendant to post a bond up to $1,000 per animal to cover cost of care. At the time of seizure, many owners don't understand the financial liability they're facing if found guilty. The 14-day hearing is where the details of care requirements will be presented and in turn prompts dialogue between the parties. Discussions may include veterinary treatments needed to pursue the animal health, safety concerns for handling dangerous animals, and many other issues that arise from caring for animals held in protective custody. It provides a mechanism to transfer custody interests to co-owners when doing so in the best interest of the animals, and this could save months of the animals living in a shelter. It ensures hearing proceeds and critical matters are addressed even if the defendant fails to appear and notify the court, preventing months of unnecessary delay while animals remain in legal uncertainty. This happens all too often, and it is the animals that suffer as a result. Shelter Bill, I'm so used to that. Senate Bill 619 as amended clearly reinforces judicial efficiency while prioritizing humane treatment and the rights of owners. And we respectfully urge you to support and pass Senate Bill 619 as amended. Thank you for your time.
Thank you, Ms. Dennison. No questions? Thank you very much for coming in. Does anyone else wish to testify on 619 who might have missed the sheet? Nope. Sounds good. We'll end the hearing. Yep. Yes. Okay. Okay. Thank you for pointing that out, because they didn't check. I might have asked. Thank you very much. Okay, Senate Judiciary is moving on to SB 558. Senator Oshler is going to tell us about the appointment of the Youth Development Claims Administrator. Good afternoon, Senator. Great to see you.
Good afternoon. Thank you, Chairman Gannon and honorable committee members. For the record, my name is Deborah Altschuler. I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Rye, and Stratham. Senate Bill 558 addresses a profound injustice that occurred last year under the cover of budgetary procedures. This is not a partisan issue. This is about whether New Hampshire keeps its promises to the most vulnerable people our state has ever harmed. In 2002, faced with hundreds of lawsuits from survivors of horrific abuse at the Youth Development Center, the legislature created something innovative, a confidential, trauma-informed administrative claims process. The genius of this system was that it protected both the state and the survivors. For the state, it avoided years of expensive trials and the risk of enormous jury verdicts like the $38 million David Meehan won, which would have been just the first of many. For survivors, it created a safe alternative to public trials where they would have to describe in open court for all to see the unspeakable acts of rape, torture, and abuse they endured as children in our state's care. The cornerstone of this process was an independent administrator appointed by the Supreme Court, removable only for good cause, someone who worked for neither side, someone survivors could trust. Last June, in an 11th hour amendment passed without public hearing or notice to survivors, the legislature fundamentally changed this system. The independent administrator appointed by the Supreme Court was eliminated. In its place, a political appointee serving at the pleasure of the governor. And worse, the Attorney General, representing the defendant state, was given veto power over any award. And let me be clear about what this means. The state that committed these crimes now gets to choose and judge and reject any verdict it doesn't like. If that sounds at all like a dystopian nightmare piled onto an over 50-year legacy of horrific sexual and physical abuse, be assured it is not. Former Former Chief Justice John Broderick served as an administrator for over 2 years. He listened to more than 1,000 survivors describe what happened to them, and he wrote powerfully about why the changes made last year are fundamentally unjust. And he asked a simple question: in what world does a defendant get to choose and remove the judge in their case and get to reject any jury verdict with which it disagrees? Certainly none that we would respect. This isn't just unfair, it's a betrayal. Nearly 1,300 survivors migrated their cases from Superior Court to the administrative process based on the promise of neutrality and independence. They trusted the system the legislature had created. Then, after they abandoned their right to a jury trial, the rules were changed. Under the current system, survivors have 3 options, and in my opinion, they're all terrible. They can go before a political appointee, knowing that the AG can veto any award and hope the state is generous, though the state benefits financially from their trauma and embarrassment. They can reject inadequate offers and go to trial. But then they face years of delay, the trauma of public testimony describing rapes in graphic detail, and the state's argument that they waited too long to sue. Or they can give up entirely, which many will, because they'll die, move away, go to jail, or simply break under the weight of waiting. And the state knows this. The state benefits from that choice. As Justice Broderick wrote, the state will benefit from a claimant's trauma, brokenness, and embarrassment. And we know what happens in public trials. David Meehan was strong enough to endure one. A jury heard his testimony about hundreds of rapes as a child in state custody, and they awarded him $38 million. The trial judge then reduced it to $475,000, less than 1.3% of what the jury said the suffering was worth, based on a state liability cap. Now, the Supreme Court is deciding whether hundreds of rapes count as one incident or many, and the state argues it's one. Even if David Meehan, who had the strength to go to trial and win, ended up with a fraction of what the jury said he deserved, what chance do other survivors have in the politicized system we've created? I understand fiscal concerns, but let's be honest about the choices this state has made. Last year, while zeroing out funding for abuse survivors, the legislature approved tens of millions of dollars for a pension plan for Group 2 retirees. That was great. But as Justice Broderick said, maybe they deserved it, but not more than the kids who have been raped. The state legislative budget assistant conducted an audit and found the fund was operating in compliance with state law. Average payouts were $543,000, not the millions some have claimed. And these are not frivolous claims. These are adults who, as children, suffered anal and oral rapes and other sexually deviant behavior at the hands of state employees. Some of the abuse was described as sadistic and perverse, all of it a betrayal. So Senate Bill 558 restores the system as it was designed. It returns the administrative position back to the judicial branch. It requires the Supreme Court appointment with input from both sides. It removes the governor's ability to fire the administrator at will. It eliminates the AG's veto power over awards and restores good cause as the standard for removal. It undoes the changes made in darkness last June and returns to the bipartisan compromise that protected both state and survivors. I know many of you are loyal to this governor, and I respect your loyalty, but I'm asking you to be loyal to something greater, the principles of fairness and justice that should transcend politics. Ask yourselves, would you want your trauma to be brought before a judge chosen by the person who harmed you? Would you trust a system where your abuser can veto the verdict? Would you consider it justice if the state that raped you as a child controlled every aspect of your compensation? These were children, vulnerable, broken children in the care of our state, and our state failed them catastrophically for 50 years. We cannot fail them again. You can vote for Senate Bill 555 ought to pass and restore a fair process that protects both survivors and the state. Or you can maintain the current system that is shockingly shameful. In his final editorial, Justice Broderick wrote, "If there was ever a time to speak up in the face of injustice, now is that time." These were children, after all, and our state abused them. Let's not continue to traumatize them with a facade of justice. We're better than that. I know we are. It's just not right. And he's right. We are better than this. I urge you to recommend Senate Bill 558 ought to pass. Thank you. Thank you.
Mark Knight. Good afternoon, Attorney Knight. I just have a quick procedural question on tolling. So she mentioned, Senator Osler mentioned they'd be running out of time to like file. Wouldn't it toll from the period that they would have had if they thought there was a settlement? Now there isn't. Wouldn't the tolling now start? Would it be like a 3-year period from now? They thought there was a settlement, so now if there isn't or is, wouldn't the tolling begin approximately now?
I can't speak to the circumstances of any individual claimant. I can only speak generally. I'll say I haven't thought
Normally,
about
it's from when you should have had knowledge that you should have filed.
Yeah,
But if, like
yes.
last year, you thought you were in a settlement, maybe the tolling would only begin now.
I don't know that there's a specific tolling provision written into the settlement fund statute.
Okay.
I will say that each of our clients have already filed lawsuits. So that's not a consideration for us, which is why I hesitate to answer. I just
Okay.
haven't thought about the issue myself.
Thank you.
Pardon me.
Chairman, I believe there's a tolling period while the defendant, plaintiff is a minor. So there is some.
Okay. Okay. Thank you. Okay, I'm sorry to interrupt you.
No worries. Good afternoon, Mr. Chairman, members of the committee. Thank you for the opportunity to testify. My name is Mark Knights. I'm a partner at the law firm of Nixon Peabody in Manchester. Together with my co-counsel, Russ Riley, we at Nixon Peabody represent the majority of survivors of abuse at the Youth Development Center who have both filed cases in court against the state and who have filed claims in the settlement fund. I'm here today to support SB 558, and I want to echo Senator Altschuler's observation that this is not a partisan issue. The concerns addressed by SB 558 involve structural neutrality, independence of decision-making, and claimant confidence in the settlement fund. Those matters are fundamental to any credible dispute resolution framework. I want to be clear about the perspective I bring. I'm not here to advocate for larger rewards or to change the guidelines of the settlement fund or the caps or anything like that. I'm not here to protect the interests of myself and other attorneys. I'm here on behalf of my clients, some of whom are also here today, some of whom you'll hear from, but there are many more who are not here today because they still want to preserve their anonymity, which they value. There are things that happened to them while they were children, and they're still deeply ashamed and embarrassed and traumatized by those things. And I'm here to speak in part on behalf of those people. The core issue here that's SB 558 addresses is claimant confidence. Administrative claims resolution systems like the settlement fund rise or fall, succeed or fail, based on whether or not the participants can be confident in the outcomes. Claimants have to believe that the determinations are made by genuinely neutral decision makers. They have to believe that the authority of those decision makers is independent of any of the parties with a stake in the outcome. The background of the settlement fund helps explain why this structural issue matters. The settlement fund was originally created back in 2022 as an alternative dispute resolution mechanism to help resolve the hundreds at that point, over 1,000 now, Superior Court cases that have been filed. Survivor participation in the settlement fund depended on a framework being adopted by the legislature that was trustworthy and credible to the claimants. We participated collaboratively with the Attorney General's office to create a settlement fund that survivors would find trustworthy and credible. And key features of that settlement fund from the very beginning, from the very first iteration of the fund that the Attorney General's office proposed, were that the administrator was an independent individual who resided within the judicial branch, was appointed by the Supreme Court, and could be removed only for good cause, and that the administrator's decisions would be final. Survivors elected to participate. They put their court cases on hold so that they could enter the settlement fund because they found that structure trustworthy and credible. And the process was later modified. I'm not here to litigate those changes, whatever the reason for the changes. They did undermine the stability. They did undermine the perceived neutrality that was essential to the success of the settlement fund. Administrative systems, claims resolution systems like these derive legitimacy from the independence of the decision maker. We're all familiar with the term kangaroo court. We understand when we hear kangaroo court that that's a court that's not fair because the decision maker is somebody who has a stake in the outcome or a thumb on the scales. The process is preordained. Where determinations are made by an interested party, that's a kangaroo court. And the participants, the claimants, and the settlement fund understand that. Where decisions are subject to discretionary rejection by the defendant, participants understand that the process itself is an empty promise. That perception affects claimant confidence and affects participation. In the months that have passed since the changes to the settlement fund structure last year, there have been a number of survivors who originally had elected to participate in the fund who have now left the fund, have resumed their court cases. And you'll hear from one of those people today. But they cite one consideration. They could not have any confidence that the determinations that would be made in the settlement fund would be made by a neutral fact finder and would carry finality. When they go back to court, they can at least have that assurance. They know they're going to get a fair shake. Jury members are truly neutral. They don't have any stake in the outcome. So if they have to go to a jury, they will. To be effective, the settlement fund has to replicate that kind of independence and neutrality. And absent restoration of that neutrality, independence, and finality, additional withdrawals are likely. I can't say what's going to happen. I can't represent what each individual claimant is going to do. I can say that that's likely. Some have suggested in the past that the current structure reflects prevailing settlement fund practices. That's based on my experience and knowledge, and I've looked at quite a few of these. I'm pretty familiar with these compensation programs, for better or worse now. I'm not aware of any comparable frameworks in which the administrator of the fund, the decision maker in the fund, is both appointed by the defendant and can reject that same administrator's awards if they don't like them. The prevailing structure in virtually all other funds is that decisions are made by an administrator whose independence and decision-making finality are insulated from the defendant. And that, of course, those are features of the fund that the Attorney General's office itself initially proposed. And those were the features of the fund that existed up until changes that were made last year. What Senate Bill 558 does is restore those features that traditionally define adjudicative legitimacy: structural independence of the decision maker, finality of the administrator's decisions. Those two changes will promote predictability. They will promote claimant confidence in the fund, participation in the fund, and durable resolution of cases that enter the fund, both for the claimants themselves and also, of course, on behalf of the state. Now, SB 558 also contains provisions concerning attorney's fees. I want to be very clear that we are not taking a position on that or that particular provision excised from this bill entirely. We would still support the bill completely. The neutrality and independence of the administrator present a distinct structural issue that affects claimants directly, and that is what we are principally concerned with. To close, neutral administration, administrative independence, finality of decisions are institutional principles. They're not partisan principles, and they should not be political principles. Confidence in neutral decision-making is fundamental to the legitimacy, the effectiveness of the settlement fund process, and as it would be to any credible dispute resolution system. SB 558 advances those principles. It promotes claimant confidence and participation in the system that the legislature has established. It ought to pass. Thank you very much for your time. I'm happy to take any questions.
Senator Alice.
Thank you, Mr. Chairman, and thank you for taking my question. I understand the issue of attorney fees that you brought up that's changed, and that's on page 2, lines 8 to 18 discusses the attorney fees. My understanding was prior to this, the change in the law from last year, the attorney could, if there was a structured settlement, let's say over 5 years, so it would be 5 payments, the attorney can receive their legal fee all up front while the victim would have to get theirs structured over time. And that was one of the rationales for changing that provision, that if it was a structured installments, that maybe the lawyer should get paid over the same installment. With that, are you saying that you don't oppose us perhaps amending this bill, taking that section out and leaving the legal fees as they are on the books today?
That's correct. We take no position on that, and as I said, if that were excised from the bill, that section of the Settlement Fund Act remained as it was, that would be fine by us.
Now, if I could ask a follow-up.
Well,
Prior to that change, in your experience representing the majority of the victims have come forward, how many of those structured settlements or structured payments were the legal fees actually paid up front, as opposed to over the course of the same period as the structured installments of the?
I can't speak on behalf of the other law firms. I will say that we had agreed to take our fees over a period of time at some point. Initially, they had begun paying up front. Administrator Broderick came to us and said, "Will you take your fees over time?" And we said, yes, we would. So I'm not certain of the exact percentage of awards where that was the case. But that is nothing that we have ever fought back against or opposed in any way. And we are fine with the law as it currently stands with respect to attorney's fees.
Thank you.
other questions? Seeing none, thank you very much.
Thank you.
Joelle Wigan.
Good afternoon.
Good afternoon.
Thank you for allowing me to speak in support of Senate Bill 558. My name is Joelle Wigan, and I've been a victim specialist and worked with victims in the state of New Hampshire for nearly 20 years. For the past several years, I've had the honor of working with the victims from the horrific physical and sexual abuse at YDC and other state-run facilities. These were vulnerable children when they were abused, no one to turn to, nowhere else to go for help. I've spent countless hours providing support to these victims as they've worked their way through the civil process. Entering this civil process, it's often the first time the victims have dared to share the details they suffered at the hands of state placement. Excruciating details to recall and to discuss. Disclosure is a process for these individuals, and it isn't done in one meeting or 1 hour. These are experiences they buried for decades in order to survive. The settlement fund created something rare and meaningful, a trauma-informed victim-centered alternate to trial. Instead of waiting years for their day in court, where they would face cross-examination and relive their abuse in an adversarial setting, survivors were given a structured, respectful forum to be heard. The administrators listened. Survivors were given the time to tell their stories fully, not rushed, not minimized, not challenged as if they were on trial. For many, it was the first time someone in authority simply believed them. The process provided predictability. Victims understood the steps. They knew what to expect. That predictability is critically important for individuals whose trauma often stems from chaos, betrayal, and a loss of control. It reduced the re-traumatization and re-victimization. The environment was far less adversarial than traditional litigation. Survivors did not have to endure aggressive cross-examinations or public testimony to receive acknowledgement. It provided timely resolution. Many victims were able to resolve their cases far sooner than if they had to wait years to go to trial. That timeliness matters. Healing cannot fully begin while someone remains stuck in a prolonged uncertainty. And perhaps most importantly, it restored a measure of dignity. Survivors left the process feeling heard, validated, and respected. The financial settlement mattered, but equally important was the acknowledgement. The sense that the state was finally recognizing what had happened to them. I witnessed survivors walk out of resolution proceedings with visible relief. Some expressed that for the first time they felt believed by the very system that once failed them. That matters. But since the amendments last year, I have also witnessed apprehension, frustration, fear, and sadness. Without consultation from those most impacted by the legislative change, for many survivors, this felt like another betrayal, like the rug was pulled out from underneath them yet again. They feel the state is turning its back on them, and they feel misled. They fear they will no longer receive a fair and neutral resolution. Trust is not easily earned by these victims, and once again, that trust has been damaged. I urge you to restore that trust by restoring the settlement fund as it was originally structured. Place the administrative office back under the judicial branch. Restore the neutral, trauma-informed process that was working. The previous structure did more than resolve crimes and these claims. It created accountability and it fostered healing. It demonstrated that New Hampshire was willing to confront its past responsibly and compassionately. Please help bring back the process that showed that New Hampshire cared about what happened to these victims who were vulnerable children when they were abused. Please show that you care about what happened to these victims. Thank you.
Thank you, Mr. Chairman. Thank you for taking my question. I understand that you testified in support of the bill.
Yes.
On page 2, lines 8 to 18, that's the provision that involves changes that would be to go to the legal fees. If this was amended to not change the current structure of how legal fees are paid in the installments, would that change your position on the bill in any way?
So I would refer back to Mark Knight's statements on the legal fees. I don't get legal fees out of this. So I'm a victim specialist that provides these services.
So you would still support it then?
If that's what needs to happen to create a neutral environment and we need to readdress legal fees, I would leave that up to the counsel or that represent these clients.
Thank you.
I was supposed to call earlier Samantha, is it Hunting? If she's here. How do you spell it? Heun? Is that you? Come on down. Oh, okay. I was told you wanted to go first earlier. That's great. We're fine. Joanne. Plur Street? Let's see what Senator House thinks.
I'm gonna say that.
You're gonna pass on that, thank you. I don't know. Johnny, I'm sorry, Johnny.
Plasted? Looks like it.
Okay.
PLA.
How do you do it, Johnny?
Good afternoon.
I got $1 betting on how to pronounce your last name. How do you say it?
Placestead.
Placed. You were close. You were closer than Senator Abbas and I. Sorry about that, sir.
That's okay. Thank you for letting me speak in the support of the bill here. When I was 13, all right, I got placed into the state confinement, and for the first time during my stay at YDSU and YDC, I was abused at the hands of the individuals that were supposed to be there to protect me. You know, I'm 47 now. I'm a survivor of this. Because of the
If it's easier to just talk to me, just talk. You don't have to read.
no,
Or
trying to
what-
catch
whatever's
me.
better
I'm
for you.
just trying to catch my breath. I'm
Okay,
sorry.
I'm sorry. I know it's,
The anxiety of being in
I
this room,
totally
being,
understand.
being around everybody.
Yep.
Is like just. It's like I'm back 13
Sure.
again.
We're in no rush.
I mean, 13 years old, I sit in a room like this trying to fight for my freedom
Yep.
and everything because I was made to be like a bad person, a bad child. You know, after dealing with everything I've dealt with there, I don't really want to get into
Yep.
anything.
Whatever's best for you.
The place was so bad that I escaped. I was AWOL 3 years. Okay. I couldn't go to school. I couldn't do what a normal child would do. The state robbed me of it. And now it's like a big slap in my face where this settlement stuff was supposed to happen, and then all of a sudden it doesn't. It's all switched around as if people are lying. You know, I'm 47 years old. I'm a true survivor. I grew up in the same town I ran to, got my driver's license there at 16 years old, got a job, paid taxes. You telling me the state didn't know where I was? But then again, they claimed they had me. No, that is an example. They made me to look like I was such a bad person back then. But at the age of 19, I worked for the President of the United States' father and mother, cleaning their swimming pool once a week. I weren't that bad person that the state tried to make me out to be, but they destroyed me by doing what they did. And not just me, there's others. I mean, I've witnessed others being abused by the state. The fund was going in the right direction. We weren't going to have to come out in public and go against these people that did this to us. But I filed my claim way back, told my story, and to little behold, two of the people that are mentioned in my statement are doing time in jail now for their crime against another child. I feel as I shouldn't even have to be here fighting for my rights or fighting for anybody else's rights just because somebody has the power to say, nah, too late, see you later. I talked to after speaking with my lawyer, I talked to the state police for an investigator. You know what they said? They tell me? Yeah, sorry for your bad luck. That's the exact words they said to me. What a slap in the face. I mean, they didn't believe me when I was a child. And now they're not gonna believe me as an adult? I mean, you guys have the power to change this back. It'll never heal from knowing what happened to me or others for what little bit of money. To me, there's no amount of money that's really gonna pay the debt that the state did to me. I mean, 19 years old, I worked hard. All right, 47 years old now, I paid my house off. Bought it when I was 19, raised my children in that same house, just to have my son go climb on a roof. And the same juvenile officer from when I was a child tried to put my child away because he climbed on a roof. Wanted to send him to YDC. I had to go to the courtroom and sit there and explain to the judge it was a grudge against me. He tried to take out on my child. That's the state for you. And it's a continuous slap in the face of us victims. I mean, put yourself in my shoes. Put yourself in other victims' shoes. We were tortured. Nobody really knows the torture that we went through. I would sit here and watch these staff members on TV say none of this happened. 100% a lie. I've sat there and told the exact ones that are on television what happened to me then. It was a lie, they say. And they're lying about it now. And I do know that I'm coming out in the open now and I'm going on television and everything. My children are going to know how much trauma I had to go through, how much I'm going through now. Yeah, there's a big effect on it. But you know what? I am a survivor. I will survive no matter what the outcome here is. But I just hope it's in the right direction. And no, the victims deserve what's right. Thank you.
Thank you for your testimony. Chuck Miles. Mr. Miles, good afternoon.
Good afternoon. You know, sure, as you just heard, it's very overwhelming. It's very difficult. It's painful. Brings up a lot of bad memories. I went through 8 years of abuse. It started in the 5th grade. It ended when I aged out, was thrown out of the system, into society, and told, you're going to be held accountable for anything you do, any way you act. There's a consequence for what you do. Where is the consequence for the state for what they did? Is there one? You know, when choosing, I'm gonna read this. I'm almost 60 years old now. You know, and I'd like to think I know a little something at being my age now. What's fair, what's unfair, what's right, what's wrong, what isn't. When choosing to participate in the settlement, I was hesitant. The settlement fund, I was hesitant. My past experiences from state placements made me skeptical. You know, I was told, we're here to help you, as I was being dragged into a cell and raped numerous times, orally, anally, locked in closets, told you'll never see your family again. You did this, you deserve it. Shut your mouth, no one believes you. Patrick O'Mara was the main perpetrator against me at the Anna Philbrook Center. a horrible place, horrible. You know, I like to refer to that place as cold urine. When I walked in there when I was a little boy, the 5th grade, that's what it was. Concrete, stainless steel. The building smelled like cold urine. That was my first experience with the Anna Philbrook Center. Years, so then I go from there, group home after group home after group home after group home. You know, every time I would go back to a public school, I was not allowed to recess. I was not allowed school lunches with the other kids, not allowed on playgrounds, locked in a closet with one teacher because he's a problem. He's a violent person. You know, I'm a very successful businessman now. I come from West Palm Beach, Florida. I travel all the way up here to do this today. I don't want to be here. You know, I have a great life, but my life wasn't always great. You know, like Ken Weiler said, yes, I was a misspent soul for a lot of years from the trauma I endured as a child. You were there to help me, and you abused me, and then you threw me out, and then you said, why do you do these things in society? You know, I had no tools to make it. I knew nothing about life. I didn't know about credit. I didn't know anything. I didn't even know who I was. You know, as a victim, I feel if the defendant, which is the state of New Hampshire, is the decider, how could we ever trust that process in light of all the abuse of victims like myself endured? Attorney John Formella was instrumental in the design and process of settlement fund. The settlement fund was working as should. Audits showed that. I don't believe any complaints were ever filed pertaining to fund. It stopped working when the state of New Hampshire decided to defund the fund in a last hour decision. The Attorney General for the state, John Formella, had zero hesitation. Zero hesitation. No one ever said, even had the courtesy to ask a victim, if we pull this fund away, you state your cases and everything else, how would that make you feel? Nothing. Told, hey, guess what? Very generic reply from him. You can have your day in court. You know, it's a stall tactic. The courts are, this would implode the state of New Hampshire. You know, all these cases. You know, you think all the, of course, I'm sure there's some people out there that are in it for a little quick money grab. But you know what? That'll work its way out. People like John Broderick would sift through that and could find that. That guy was a delegator of justice for chief justice for years. Guy's not an idiot. You know, he was great. He was the perfect person, I thought, for that position. You know, like I said, he had zero hesitation with the fund, leading victims to myself to once again feel betrayed. The fund was set up with guidelines. It was to be a fair, neutral process. John Broderick was that, a fair, neutral decider with no stake other than giving some closure for us victims. I believe John Broderick understands the impact abuses cause children. They carry on through adulthood. John Broderick was a beacon of hope to me. You know, I'm sure he was to a lot of other kids too, you know. Right now, I'm a 58-year-old male adult, but guess what? I was a little boy. There's a little boy still trapped inside of me that wants some justice. I do. I want some justice for this. And John Broderick was a beacon of hope to me in getting some degree of closure. John Broderick has the knowledge and experience as an esteemed server of justice for decades. I believe he was a delegator of fairness for all victims. We state our cases for those reasons. It's very clear state of New Hampshire wants the only involvement in this event is to defend their unfairness toward us victims. I respectfully ask if this was you, would you feel this was fair? In my mind, letting a defendant control a fund with authority to veto cases at their will would be like Jeffrey Epstein and Ghislaine Maxwell presiding over cases against them, brought against them, and accusations made against them. Would it not? Would it be the same? Or how about this? How about letting Osama bin Laden decide over the victims of 9/11 and that settlement fund? Would that be fair? Nowhere, I'm a very smart guy by my own means and ways, okay? Nowhere does it ever, if you were to look up and try and find a defendant operated and controlled and delegated a settlement fund. That's never happened. There's an independent operator for that reason, because that you're unbiased, neutral, you know? I feel this is a stall tactic that eventually will implode the state of New Hampshire. In the meantime, victims are benched with little to no hope or insight. Actions tell the story. The state's actions clearly scream unfairness for all of us victims. You know, I can't express enough, and I'm sorry for being emotional, being loud. I am angry. I'm tired of being angry. My brain hurts from this. You know, when I was a child, I would sit in this little cell and I would sit like this and shake and cry, and I would, why did this happen to me? Why is this happening? You know, physically hurt. I physically hurt from the abuses. You know how small my body was? This man was 350 pounds that violated me. You know, and then I'd get shot in the ass with Thorazine because I would freak out and bang my head against the door of the cell I was locked in Anna Philbrook with Thorazine, and then wake up on a bed that I was strapped to with Patrick O'Mara standing over me saying, you gotta take it easy. You're never gonna get out of here. These are just massages. They're okay. They're here to help. We're here to help you. I want to help you. You know, I actually did try and run away from there. Pulled up a manhole cover in the yard there at Anna Philbrook Center, right down the street here in Concord, New Hampshire. It was in the sewer system. Guess who they sent in to retrieve? Me and 3 other boys that were being abused, that we had all conspired with each other. And we knew, we came together. We were like, did Pat come into your cell last night? Yeah, we could tell. I could tell when those other victims had been raped by him by the look on their face the next day. You know, so we tried to escape. We're in these sewer tunnels. Patrick O'Mara comes in there and drags us out and tells us, if you say one word, you'll never get out of here. You might not even live through this. And to bring up YDC, that was a big thing that all these group homes in Anna Philbrook always said, you keep acting up, you do anything that we don't like, we're sending you to YDC. You know what happens to little boys at YDC? You know, horrible, horrible. You know, what if I was your brother? What if I was your son? You know, what if I was you? What if you were me? You know, my biggest thing is, the state took my ability to make it in life. I made it on my own. You know, with nothing. You know, I blame my family. I have a huge family up here. You know, they're business owners, they're landowners, they're voters. They're good people in the state of New Hampshire. New Hampshire is a beautiful, great state. This is a horrible thing to have on it. Why continue this? Don't you want to feel proud? Don't you want to feel good? Hey, listen, we made a mistake. We're going to stand up and we're going to make it right. Let's make it right. You know, I've made poor choices in my life. I've done bad things. I've done stupid things. But guess what? I put my hand up and made myself accountable and got past it and took responsibility for that. That's all I'm asking for. I'm not looking to bankrupt the state of New Hampshire, you know, with some claim. I don't want $38 million. I'm almost 60 years old. How many good how many good years of my life? I'm a severe diabetic. You know, I have problems remembering things. Neurologically, I found out from my doctors, you know, victims of trauma when you're young, that it causes neurologic. Sometimes I get blocked from this when I try to convey myself of what it's done to me. You know, what it's actually done to me. It's hard. You know, it causes pain in your brain. You know, I'd like to have some years of, I'd like to say to my 89-year-old mother that feels completely guilty about this before she dies, you know, that I didn't talk to for 20 years because I blamed her for me being in those schools. I said, you let them do that to me. You know, she lived with that. You know, I'd like to say to her, hey, you're getting a little bit of closure too. You know, she asks me all the time, how you doing, son? You know, are you getting anywhere with this? You know, I appreciate your time. I appreciate you listening to me. And if you have any, do you have any questions for me?
Appreciate it. No, it was very hard. Thank you.
You're welcome.
Ann Galt Zimmerman.
And I hope it's okay. I've got my law partner, Michaela Oliver, with me, just in case there are questions she can help me answer that maybe she's got some perspective on. I don't, all right?
Sounds good. Thank you.
It's a hard act to follow, and I appreciate them both coming here today. I'm an attorney in Manchester, New Hampshire, and our law firm also represents some of the victims of the YDC fund, of the YDC process, who have claims through the funds. I appreciate everything that Attorney Knight's already said, so I'm going to try to keep my comments brief today. But I will say that the two gentlemen you just heard from echo a lot of the things that we hear from our clients. It is very hard not to know these people, and I don't know them in particular, but these victims, and not be really moved by their stories. One of our first clients was someone who, I believe I was the first person he ever told what had happened to him. He made me cry, just like I might cry now. I'm kind of glad WMUR has left before my testimony, so we don't have Anna crying on the news. And his case did resolve through the fund. He had not filed in court. Most of our clients have not. They elected to go through the fund because of the privacy, because of what it offered, for security, for dignity, for the way that they wanted to proceed with their claims. And when his case resolved, it was one of the early ones, closure is sometimes an overused word, but it gave him great closure. It was the first time in his life he felt someone saw what happened to him, heard what happened to him, recognized, and he felt like the state was taking responsibility. And that claim was resolved just with the Attorney General. We didn't need an administrator, but of course we did need an administrator to approve that resolution. I raise that case because that individual died of cancer since then. And I think of all my current clients who are in limbo and we don't know what's going to happen to them. We gave him, the state gave him, you all gave him a gift in the ability for him to be heard, the ability for him to be felt, the ability for the wrong that had happened to him to be acknowledged before he passed. Right now, what our clients find is that they are in a case, I would use the word purgatory. They are stuck. They're not people who can fall back and say, let's go to court. They'd have to withdraw from the fund. And if they would, and they don't know right now what's happening. Should they withdraw? Should they go try to start at the back of the court process now? They enter the fund relying on the process that was put into place by this legislature and our governor, relying on the representations that were going to be made, that there was going to be a neutral, fair administrator who would hear their claims, and that they could proceed in this way. They poured their hearts out to attorneys. They poured their hearts out to the fund. They wrote down their stories. They signed on their stories. They relived things that had happened to them, and now nothing's happening. And that's my main reason for being here, because nothing is happening. And I don't know how to fix that under the current system. No one is being appointed. And so we don't have a fund administrator. And time again, I'm telling these individuals, like, I don't know what to tell you. I'm sorry, I don't know. And I feel like I'm re-victimizing them. I feel like they're feeling abandoned. They'll tell me they're feeling abandoned. They are, after doing what they saw as their part and pouring themselves out into this process, they're just stuck. And it's not fair. And I really hope you all will do something to fix that. Senator Abbas, I don't mean to anticipate a question from you, but I'm going to address it just in case you don't ask it. I have no problem having the attorney fees provision stay as it is over time. We, from the beginning, said that we'd take our fees over time. I see why there's some resistance to that. I'm 56 years old. If I get fees over 10 years, I'm really hoping I'm retired before that happens. Firms change in those time periods. Like, there are, I think, legitimate reasons why people had concerns about the duration in full, but we've always agreed to have our fees over time. And I would be perfectly happy with the statute staying as it is, if that allowed, particularly if that allowed this process to get back on track, get an administrator appointed, and allow these people to move ahead with the processes that they relied on and counted on when they chose to enter the fund.
Will you take a question?
Absolutely.
Thank you, Mr. Chairman. Thank you for taking my question. I look at this bill, there's really two issues it addresses. One is the attorney fees, and then one is the process of who's appointed and administers these.
Yes.
So I guess one would survive without the other.
Yes.
I'm looking at what's in front of me, and it has this provision. With the amount of cases you worked on where there were structured payments over several years, were those cases where your legal fees paid in a lump sum up front or paid over the course of the structure?
For the ones that the client's fees were paid over years, our fees were paid over years too. We had a couple at the beginning where nothing was getting structured out. So they got paid their full amount at the beginning and we got paid our full fees at the beginning. But the ones since then that have been over time, our fees have also been taken over time.
Thank you.
Yep.
Senator Oshel.
Thank you, Mr. Chair. Thank you, Attorney Zimmerman, for taking my question. So now we've settled any issue regarding the attorney's fees, that you would be just as happy to, I understand, take that out of the bill, leave it as it was.
Yes.
Not an issue. So on behalf of your clients, the issue at hand is, you've mentioned in your testimony that we haven't even hired an administrator.
Correct.
Right. So for your clients, hiring an administrator who would come from the executive versus the judicial, knowing that the executive office can veto that and involve itself in the process. Is there hesitation from your clients to continue through this, knowing that there is this inherent, what it seems to be, at least in my opinion, an obvious conflict of interest between being the defendant and the arbiter?
I think it raises a lot of anxiety, and I think it raises a lot of concerns, like, what does this mean? Is this person going to be fair, neutral, and impartial? I think their primary concern is, can we get a fair, neutral, impartial person in there and get this process started? I'm not sure if that directly answers the question, but I hope it does.
Thank you. Do you wish to also speak?
I have no comments. I'm here in case one of my clients was, I could provide insight into their experience.
Okay. Thank you both very much.
Thank you.
Samantha, now it's your time.
Good afternoon. Thank you, Mr. Chairman and members of the committee, for having me today. My name is Samantha Herring. I'm an attorney representing claimants before the YDC Claims Fund, and I'm also a member of the New Hampshire Association for Justice. I'm here in support of SB 558 today. Like others, I really want to get the process moving for my clients who are struggling to deal with the trauma associated by the lack of action after coming forward. I'll keep it very brief because most of the comments that I intended to make have already been made by others, and I don't want to repeat that and waste your time today. I'll just say that I would echo the concern that we need to get an administrator in there who is impartial, fair, and neutral so that the process can resume functioning again. And I would also say that with respect to the fee provision, if the law were to stand as it is, I would be perfectly fine taking my fees over the same duration as my clients as well. And I would like to yield to you folks in case you have any questions for me. Thank you.
Senator Evans, I'm sorry, Senator Carson, no, your turn, you go.
Good afternoon, Attorney, is it Herring?
Yes, thank you.
Thank you for being here today. Have you or any of the other attorneys reached out to the governor and asking when are you going to appoint, or when are you going to nominate? Because she would nominate and the person would go through the hearing process. It'd be a public hearing about whether or not that person would be right for the position in front of the executive council. Has anybody reached out to the governor to ask her where she is in this process?
I have not reached out to the governor myself, and I can't speak for other attorneys, although I'll say I'm not aware of any attempts to contact the governor directly. I can tell you, Senator, that the Attorney General's office and Claimants Council are meeting next week to discuss names that would be then submitted to the governor in hopes that she will select one of those or maybe find a candidate of her own choosing for us to consider as well.
Thank you.
Attorney Evans, you're our attorney, but Senator Evans. Many hats.
To Senator Evans today. Thank you, Mr. Chairman, and thank you for taking my question. And you've heard me ask this several times, but in your practice, for any of the settlements that you were involved in, whether it was structured, were all of your legal fees paid upfront or over the course of the structured settlement?
Not all of them, and at the time, I should clarify, I was employed by Shaheen and Gordon with that firm. Now I am a solo practitioner. However, at that time, initially, there were some cases where claimants were paid over duration and attorney's fees were paid up front. We quickly realized around the same time as Administrator Broderick that that was going to be a real problem for the amount of money in the fund. And Shaheen and Gordon therefore offered to start taking fees over time to try to alleviate that burden.
Follow-up?
Thank you, Mr. Chairman. Were there any of your colleagues in other law firms that were opposed to taking over a period of time? Because the reason why I'm asking these questions is that was one of the major problems with the fund, was that you had structured settlements over the course of a time period. And the intention was, when that was done, was that the legal fees would be paid off at the same time, but they weren't. They were being paid up front. And as you can tell, some legislative bodies would always move as fast as people would like.
Yes, there were some other folks who were resistant to taking the fees over time. Prior to the legislative amendments, however.
And when you say folks, you're talking about the law firm.
Yes, other attorneys, other law firms. And I don't want to speak for them, but I'm aware that some were resistant to taking them over time. However, before the legislative amendments passed, I would say for about the 4 to 6 months going back prior to those amendments, all firms were taking fees over time that I'm aware of. There are some out-of-state firms that I'm not familiar with who may be on a different schedule, but I couldn't speak to them.
Thank you.
Thank you for your testimony. Sorry, Senator.
Thank you, Mr. Chair. Thank you for taking my question. I think we've covered the fee structure that every attorney that's appeared here today is willing to take over time. And the crux of this bill is really about where the administrator comes from, whether the administrator is a political appointee or the administrator is chosen by a different branch of government, to be fair and impartial, knowing that the other branch of government can veto that recommendation, right? Is that why you are here today? Is to advocate for an impartial, not political appointee administrator, not just any administrator?
Yes, I think that we need not just any administrator, but someone who is impartial, fair, and neutral, who has final and binding decision-making authority. Certainly, if either of the parties notice that there's been an error in the decision, they should submit the equivalent of a motion for reconsideration to alert the administrator to that. But the decision needs to be final and binding in his own, or her own, excuse me, and not subject to a veto by the party who's effectively the defendant.
Thank you.
Seeing no other questions, thank you very much. Does anyone else wish to testify in SB 558? Yes, sir. Good afternoon, sir. Just say, push the red button and tell me who you are. Thank you.
Good afternoon. My name is David. I don't know if I have to give my last name. I have no clue why I'm here
We'll let it go.
because we had an agreement. And I'd like to know if impartiality, neutrality, if it's such a bad word. How many of us, or you, if you had a dispute with someone, wouldn't you want somebody that was impartial, unbiased, not affected by their, whatever? Neutral. Apart from the attorney fees, well, I don't know anything about that. That's all business. That's what I'm talking about is how it affects trust. And I would ask that each and every one of you reach into your hearts and do the right thing. So I again ask, why are we here? We had an agreement. The legislator met. From what I understand, I'm sure there was numerous committees. I don't even know how laws are passed. I don't know what you guys do, but I'm sure you're all very wise people. And I'm here today also. I felt the spirit move me to be here. I don't know how to speak in public. I don't want to talk about everything that happened. It's hard on everybody. Tonight on Channel 9, there's a group of people that claim nothing happened. Well, everyone's entitled to their opinion, including Senator Wheeler. But for me, I took his suggestion, and I'm fortunate to have insurance that pays for medical help. However, after a very long time in going and being involved in treatment, there's only one objective I have, is to heal from the traumas that happen. I'm 64 years old. I mean, the state knew they made an agreement. Why all of a sudden change the agreement? I mean, what kind of law is that? What kind of people are we? What kind of state do I live in? It's supposed to be live free or die. We're supposed to, I've always trusted, I'm not a perfect person. I'm probably on the opposite side of perfection. However, I've always trusted that system, those protocols we have in place that allow people justice. And what I don't understand is looking at a lot of sexual assault cases, civil cases, it seems like those standards don't apply to us because we're those that were thrown away. We're those that were, some people say, like these people on the news that are going to be tonight, say that we needed to be protected from ourselves. They needed to protect themselves. Well, it's hard on all parties. It's hard on the defendants. It's hard on all parties. And I just hope that you guys, the senators, can reach into your heart and just do the right thing, because the state made an agreement, we made an agreement. I mean, I already lost faith in the system a long time ago, unfortunately, and I apologize for like even bringing that out. But your decision affects thousands of people. I mean, I don't know if they're all telling the truth. Nobody does, But we need a fair way of resolving these issues. I mean, unless you guys make the right decision, you guys are all gonna be back here on some other issue, some other thing. I mean, to me, I'm not an attorney, but common sense tells me that if you have a dispute with somebody, you have an impartial person to make a decision, someone that doesn't have any vested interest whatsoever. And I mean, whether I trust the system or not, it's all irrelevant. You know, whatever happens, I feel God's in control. However, there are other people out there that are suffering, and I can't speak for them, but I can speak for myself from what I've learned, that the way this settlement currently stands, it's not going to work. Well, it's not going to work for me. And it's just not working. It's just going to cause delays, more. And you've already heard all the parties speak about it. I'm sure you even know the trials of things. I don't want to talk about all that. I just want to say that it's all about impartiality. And impartiality and neutrality is not a dirty word. As far back as the Old Testament, when there was a dispute about a child, I mean, they brought an impartial decision. It's our humanity. We don't allow one group to make decisions for another group. We have to have somebody neutral, independent, that can, and I'm sure there's protocols in place that if the state believes, no, we don't believe this, well, then whatever protocols are in place, address them then. I guess reconsideration, whatever. I'm sure there are protocols to address all these other issues. But the most important thing, it's not the attorney fees, it's not how much someone's getting, it's impartiality. And it's not a dirty word. That's all it made me feel like. I mean, they made it seem like the abuse, the trauma was okay, but the impartiality is such a dirty word. Oh, stay away from that. We don't want an impartial person. And that's all I wanted to say. I want to say God bless you all. You have a tough job. And I just ask that you reach into your heart and do the right thing. And I'm okay with that, no matter what. I forgive everyone who's ever done anything.
Thanks for coming in today.
I forgive everyone who's ever done anything against me, and that's what I choose. And God bless you all.
Thank you very much.
Thank you for hearing me.
Anyone else wish to speak on 558? Come on up. Usually we get the whole name, but if you just give me a first name, that's fine.
My name is Jeff Merrill. I started out kind of similar in the Philbrook Center. I don't even know if I can even do this. But when this first came about, I had a friend reach out to me that when I was back in a teenager, they reached out to me and heard about what was going on. And he said, do you remember the letters you used to write to me, you know, from the Philbrook Center and YDC when I went into the service, and the things that you used to tell me, you know, how they were treated and stuff like that? And I'm like, yeah, I kind of remember, yeah. And I did remember. Well, he actually saved some of the letters from the Air Force. And I said, I don't want no part of that. He kind of said, you know, maybe you should look into this. You know, maybe this is your past. I said, yeah, but I don't want no part of that. That's my past. I'm trying to bury it. And I just, about 2020, I reached out to Russ Riley, and I told him my story. And actually somebody gave a shit, you know, because I would never, ever step forward just because I wanted to forget it. My past before YDC was bad for my parents and everything. The state, when I was in YDC, you know, I went AWOL from Anna Philbrook Center, just like the guy that I heard. I don't know him, but his story was so much familiar. But the Thorazine, throwing me on the bed, strapping me naked to the thing, shoving the needle in your ass, then throwing you, they called it was like a rubber room, but it was like, well, not rubber. They go work it out in there, kid, you know, and it was like, it's just the way, it was horrible. It was, if that was today, a faculty and today, the way the world is today, there's no way. I mean, you can't even say the wrong thing. And it was inhumane. And when I got turned over to full state custody, I mean, there was, I'm not saying every staff member, but there was certain ones, when they knew that they had full control, there's no one coming to visit you. There's no one coming to visit you. When you're here till you're a lifer, they call you. I got let out, like they let me out 2 days before my 18th birthday, and opened the door, there you go, kid. The education there was a joke. I mean, when they walk us down to the building, we go in there, they lock the door. There's no teacher. I mean, it's just, the state should be accountable for what, we were kids, it wasn't our fault. You know, and why I was in there was because I had no family. It wasn't because I did a crime or, it's just, that's where I ended up. And to me, for them, and then when I was first in it, there was no settlement fund. You know, it was just like, you know, you're gonna hear your day in court, and then the settlement fund come on. I'm having a hard time wrapping all this stuff together. It took me a lot to freaking even come here. And he's like, well, maybe you should do this. You don't have to. Then you don't have to go up there and like do what I'm doing right now. Kind of. I didn't want to ever have to do this. You know, and I get there has to be there's two sides of the game. You know, I mean, there's you guys, like, you can't, like, I don't know what I'm trying to say. But to have like this thing, like with having, well, they came around with a settlement fund, and it made an easier way for us where we don't have to go and do this, what I'm doing right now. You know, make us a nervous wreck. I'm ready to have a friggin' heart attack right now. And it's just, and trying to avoid that. And then they come out with a settlement fund, and then this stuff that happens now with, like, it's almost like having you have a football team, you're playing each other, but you have the same, but their coach is coaching you. I mean, to me, it's not fair. It's a no-brainer. It's like, how can that should be illegal. It's not even, doesn't even make sense. Like I went through a divorce like 5 years ago. We have a mediator, you know, and that's kind of like, you know, but it's somebody on mutual grounds. I mean, it's like, I don't even know, maybe I said too much, but I'm just like, this doesn't make sense. It doesn't make any sense what's happening right now. It just doesn't. And I just wish if you guys, whoever has the power, I mean, I know God has the overall power, but just do the right thing. You know, it's just, you know, I think we all can say it doesn't make sense. It's, you know, thank you for your time. I'm sorry.
Thanks for coming in. Appreciate
I'm sorry.
it.
Thank you.
Have a good day.
Anyone else change their mind, wish to testify? I usually don't, but I will allow it just if you'll be brief. Yes. Yes, Johnny.
Thank you again.
Since I said your name wrong the
Johnny,
first time.
please.
No, I know who you are.
All right.
I got it now.
Just sitting back and and listening and stuff about, like, the victims that have already been paid out through this settlement fund. Okay. Now, anybody in this room here lose anybody to, like, death lately of, like, drug overdose and stuff? I mean, with this settlement fund, there's a lot of people that are known addicts and are into this settlement fund from the abuse that was gone on and stuff. But I mean, is there a way that if we can get this switched back the way it was, we can protect these ones that are addicts, that they're not just gonna get this money and go out and die because of the drug fight that's going on too? I know just recently I lost somebody that was approved by the settlement fund, and he was down the wrong path. He just died the other day from an overdose due to the fact that he had all this money and stuff. Like I said, I'm a survivor, all right? I want to see victims survive. I want to see all victims get their justice. That's really all I would want to bring to the board's attention.
It was good. Well spoken. Thank you.
Thank you, guys.
Are we all set? Everyone had their little opportunity. Thank you all for coming today. That ends SB 558.
Excuse me.
You have a cold too? Oh, sign allergies? Just sign it. Hi.
You want to see it?
We'll come out of recess.
Senate Judiciary will come out of recess. We're going to hear SB 414, an act relative to enforcement of marital property settlements. Senator Ellersler, good to see you again.
Thank you very much,
I bet you'll be fast.
Mr. Chair, and good afternoon, honorable committee members. For the record, my name is Deborah Altschuler. I represent Senate District 24, which includes the towns of Exeter, Greenland, Hampton, Hampton Falls, Northampton, Rye, and Stratham. Senate Bill 415 addresses an ongoing deficiency in the judicial system. Over my past 3 years in the Senate, I have had multiple women reach out to my office with the same problem. They have sought legal relief after being granted divorces, not no-fault divorces. All of the women who have contacted my office have their own unique experience, but one unifying theme: the courts failed them. Judgments for alimony, child support, health insurance, homeowners insurance, mortgage payments, all court-ordered to be paid, had been left ignored. So what can you do if you have been granted a divorce and one party is ignoring their responsibilities, often to the detriment of the other party? You go back to court and you file a motion of contempt, and then you wait. You wait for a hearing that can take months to schedule. Meanwhile, the bills pile up. Perhaps to bridge the financial gaps, you take out credit card debt, anticipating the courts will, of course, back their original order and force your ex to abide by those court orders. Then the hearing comes, and you and your lawyer, who you also owe legal fees to, but they've been accommodating your payment schedule because they know you still have to pay the mortgage and health insurance and all the bills that your ex had been court ordered to pay in the final divorce decree. But the ruling doesn't happen on the day of the hearing, so you wait. An order is granted, and again, in your favor, but no enforcement. So you start the process all over again. One phrase said by one of the women abused by this unending legal foolishness, who actually has given me permission to let her know this is Sue Schwartz. She's a constituent of mine. She said, every time she learns another one of these situations happens, she said, why am I being punished for my ex's bad behavior? I just want my peace. Indeed, why? Senate Bill 414's power is on line 4. Quote, the court shall fashion, for you, a remedy that immediately rectifies the cause of the contempt. And it's immediately. Allowing contempt to go on and on and on indefinitely, with the only consequence being for the aggrieved party, is unjust. I respectfully ask the committee to recommend Senate Bill 414 ought to pass and hasten the relief of Granite Staters caught in a labyrinth of the legal system. Thank you. And I'd like to introduce Sue Schwartz, who will give her personal experience. I'm happy to take questions. Sorry, I didn't mean to interrupt you there. Yeah.
Go ahead.
Thank you, Mr. Chairman. I see the remedy here, what the court's allowed to do. Would you be open to an amendment that also included the ability to get reasonable legal fees, which may be in another section of law, I would have to check, but if it's not.
It's in the next section.
It is. Never mind. If it's not in the next section, though, would you be supportive of it?
Yeah.
Senator, can I ask a question?
Yes, please.
So I used to do a lot of divorces
Yep.
years ago. And when I represented, we'll just say the men in these cases, who were usually the ones who had to pay, oftentimes they couldn't afford the settlement. You know, they couldn't afford the family they left. Now you have two houses. I'm interested in seeing if Sue says that he's just didn't pay and he had the ability. Oftentimes gentlemen will say they have these hills that they can't manage to pay. And it's, you know, they couldn't, usually I found most of the reasons, a lot of the reason people would get divorced, they couldn't afford the situation they were in. Now you've added another house the burdens become unduly burdensome on one party. Have you found that in the people you've been talking to, that it's an inability to pay or
So-
a desire not to pay?
Thank you for the question, because it actually, the question really delineates where some of these issues have been falling. In the women that have contacted my office, and honestly, the first call that came in, I was at a loss, because this is not a no-fault divorce. They had a judgment in their favor, and through the courts had their the other party, their ex, had demonstrated assets, that they had available assets, but they were choosing to delay, not pay, knowing that they could get a continuance, or they would be putting their ex, women who reach out to my office, in a position where they would have to go to court and file the contempt motion. And so they're due to pay a bill on the first of the month. They don't pay the bill. So now we're towards the end of the month, the bill still hasn't been paid, and the next bill is coming up. So you go to court, you file a contempt motion. Now you gotta wait for a hearing. The third bill is coming up, still has to be paid. Meanwhile, the other party is not necessarily in financial straits. The court has already determined that they have an ability to pay. And if there is an inability, that's a different section of the law altogether. This is specifically about people abusing the courts.
Senator Carson.
Thank you, Mr. Chairman.
Thank you.
Thank you, Senator, for filing this
Thank
bill. It's been my experience, because I've also had multiple women over the years reach out because they're being victimized by the court.
Mhm.
And many feel that they've been victimized by the court. Would you agree that oftentimes this is more about power and control of the ex-wife? That they have lost that because they're now legally divorced, but they also still want to exercise control. They're angry, they want revenge. I mean, the list can go on and on and on, but they continue to victimize their ex-wife. Oftentimes, they've moved on to another family and they don't feel they need to support the first family. So would you agree that a lot of this really is about power and control and using the court system to victimize their ex-spouse over and over and over again?
I don't think I could agree any more that the incidents, examples that you laid out are exactly what comes into my office too, is that it is the last remaining link, is the health insurance payment or the mortgage payment or the control over a joint piece of property. It is, or some sort of inheritance. It is the last link that they can keep pulling on to retain control. Thank you for that question.
Thank you for answering.
So first I'll answer
Just say your name for the
I'm
record
sorry,
and
it's
where you live.
Susan Swartz. I currently live on Cape Cod, but when I was with my ex, we lived in Mount Vernon, New Hampshire. To address what you said, it's called coercive control, and it's become quite a thing. It involves financial abuse, emotional abuse, and right now in the country, it's the number one form of abuse. And in 99% of domestic abuse cases, it is present. And in my case, my ex has plenty of money to pay me. He has just chosen not to. So I'll just give a little history. My ex and I met when I was 18 years old. We went out for 2 years. We got married. At that time, I was a controller. I have a degree in accounting. He wanted to build his career. At the time, he was a service manager at a car dealership. And so when we had our first baby, I gave up my career and I supported him in getting his. And he did. He became very successful, running a bunch of car dealerships, making over $1 million a year as CEO. So in June of 2019, I filed for divorce in Manchester Family Court for infidelity and what they call injurious conduct, what I will call abuse. The last year I was with him, I faced every kind of abuse there is, physical, emotional, financial. And so when I filed for divorce, I moved down to our Cape house. And that's why I'm down there. He was in Keene, New Hampshire at the time. Fast forward, of course, pandemic did not help anything. But my ex used it to his advantage. He was financially abusive at that time. I had hardly any money to live on. I did survive just on credit cards. So by the time we went to trial, I was about $120,000 in debt from legal fees. 3-day trial in August of 2022. I was awarded the divorce in September, a month later, an almost 30-page document, which I gave you copies of, awarding me the divorce for infidelity and for abuse. And there was quite a settlement package that was put together. My ex asked for reconsideration. He was denied. And then in December of 2022, he appealed to the Supreme Court. And during the appeal, I will say it was pretty quiet, but I was left in limbo one more time. No financial relief other than my alimony, my $120,000 debt at trial now ballooned to $200,000. Interest rates went up, the minimums went up, and I was drowning in debt. Thank God the Supreme Court came out with their decision when they did, because I was almost bankrupt. So at that point, March 2024, the Supreme Court came down with their decision. They denied him his appeal 5-0, and they reaffirmed my entire settlement. And at that point, he once again asked for reconsideration. He was denied. May 1st, 2024, my divorce became final. And so following that, these past almost 2 years, he has not abided by one thing in the agreement. I sit here today, I am 11 months without alimony. I was entitled to a year of health and dental. He canceled it after 5 months. I was forced to go on COBRA. He has never put the life insurance in place that he was supposed to. I am owed back alimony. I am owed for my legal fees. I am owed for my debt. There's a bunch of other things that I am owed for, and I haven't gotten the money. We just had a hearing in October and November, October 30th, November 3rd. And the last day of the hearing, we told the judge, I need financial relief, immediate financial relief. And, you know, my ex, of course, was claiming he doesn't owe me a dime, and we had put everything together neatly for the judge to see what had gone on. And I can tell you, in the last 2 years of dealing with Judge Bedrick, anytime we filed contempt, it was ignored. And when he stopped paying my alimony, even though he had been told by Judge Bedrick 3 times that he had to pay, Judge Bedrick didn't enforce it, and nothing was ever said. And in July, my ex actually bought a brand new house on the Cape. He had been told not to spend any more money. He's not paying me my alimony. He put $260,000 down on this house. He put another $60,000 into it in renovations. And he also committed mortgage fraud by lying on the mortgage application. And Judge Bedrick never said a word. And what we found out during appeal, it's like such a messy story, but during appeal, my ex dissipated marital assets. He did not abide by the anti-hypothecation order that was in place. He bought himself a boat. He refinanced the house he had in New Hampshire. He bought his girlfriend a car. And then he invested $500,000 on a Cinerama franchise on Cape Cod, 5 miles from me. And it was just going through his financials, doing a lot of research, that I was able to even uncover the Cinerama franchise, because it's not under his name, it's not under Cinerama, it's under just another name called Sandy Harbor, something to that effect. But I included in your packets a spreadsheet of the money that he spent while we were in appeal, and it's over $2 million. I'm just blown away by everything that's happened. I mean, this was not a short little relationship. Throughout the entire process, he's done other things to me. He has filed false police charges on me twice. He has defrauded me on a vehicle. He filed a civil suit only to drop it 3 months later. He was, for a long time, logging into my alarm system to see if I was home, or he would go in and he would change the code and I would have to get the police involved. He has destroyed our family. My son, he abused him terribly. My son has just walked away. He's turned my daughter against me. My family wants nothing to do with them. It's been horrendous, but I ended up putting my house on the market in December. And I had told Judge Bedrick if I did not get immediate financial relief, that I would have to do that. And he had asked me during the hearing, how are you paying your bills? How are you doing this? I'm not. I'm barely surviving. I'm in credit card debt again. I owe my attorney. And so I told him, I'm going to have to sell my house if you don't give me any kind of relief. And by mid-December, there was no decision from him. And so we filed an amendment and we told him she's had to put her house on the market. And he denied the request for immediate relief. And as I sit here today, we still have no order from Judge Bedrick. And he has enforced nothing. He has done nothing. He has never held my ex accountable. And he's just, there's been no repercussions for my ex. So why in the world would he abide by anything when he's never been made to do anything he's supposed to do?
Thank you. Have you thought about filing a complaint against Judge Bedrick?
Yes.
Because you do have the right to do that.
I know, but my lawyer had asked me to wait until after the decision came out. And I guess I want to address that a little bit too, because other than complaining about the judge, there is no other mechanism in place to complain or talk to anybody. And I recently filled out something called the Circuit Court Concern Form. You can fill it out online and it goes to the admin offices. I can also tell you, I have written numerous emails, made phone calls, and written letters, all to be ignored and all to be told, I don't know what to tell you. You need to consult with your attorney. I mean, my attorney, I've paid between $350,000 and $400,000 to. It's ridiculous. And my ex has probably paid the same. You know, so I fill out this court concern form, which, you know, on the website, it tells you, you know, if you have concerns, fill this out. Well, whoever got it contacted my attorney and said, well, she shouldn't be doing this because she has legal representation. Not the fact that I told them I'm losing my house and I'm going to be homeless. No, they were more concerned that I had legal representation and filled this form out. It's been a despicable situation. And, you know, I really don't know where I'm going to end up. I have 2 small dogs. You know, my family can't take me in. They don't have room for me. So, you know, I may end up in the basement of one of my friends' homes. But why? My ex is sitting there with a business debt-free, driving around in a vehicle debt-free. He has got a boat debt-free. He's got a small mortgage. And I'm sitting here with nothing. And during this whole procedure, he has made over $5 million. And he lost his job intentionally because of this business that he bought. He walked away with $1 million in retirement. And I am sitting here with absolutely nothing.
Senator Abbas. Thank you, Mr. Chairman, and thank you for taking my question. Was your ex-spouse ever held in contempt of court?
Never. And do you know how many times we filed on him? Too many times. It was ignored every single time.
And so the issue is that the judge would not act on the contempt complaint that was
never acted on the contempt. Never at all. It would always be brushed aside, pushed aside. If you look at the first page of my divorce decree, you'll see that the judge requests him to give over financials that to this day he still has not given over. And he should have been held in contempt back then. But this judge, never.
Thank you.
Senator,
Other questions?
may I
Yes,
add one? With regards to Senator Carson's question about doing a complaint against a judge, the other women that I have spoken to have also been reticent to complain because they're still going before this judge. So it's, they're in a really uncomfortable situation because they still have to go before the judge that they will launch a complaint against.
And we also filed to have the case moved to complex court. And the judge that's in charge of it now got to make the decision and he denied us, which makes no sense to me whatsoever. Why would he be, why wouldn't somebody else at least review, why we're asking for, the move? But he just denied us.
Go ahead, Senator Carson.
Thank you. Senator Altshuler, I would suggest that you have a conversation with Ellen Christo. She's the Chief Administrative Judge. I would very, very strongly suggest you do that. And if you need backup, let me know.
Thank you. I am.
Senator Epps?
If I may, Mr. Chairman.
Yes.
Perhaps we can consider a statutory time period when, because of contempt, you have an order or a judgment or a decree not being followed. So normally you would need immediate relief or action right away. And apparently, even if we were to pass as it's written, it may not solve the problem that if you can't get the court to act on it. So if you create a strict time period,
Yeah,
30 days
it's been 2 years now.
So define the immediate on 4?
Perhaps, Mr. Chair, if I may respond.
Yeah.
Perhaps take into consideration a time period when the complaint for contempt would have to be decided or ruled on by the court. And if the parties agree to push it out, that's different, but
Right.
If you can file as many complaints if you want, if no one acts on it, it may not, this is an improvement to the existing law, but it may not solve the immediate problem that I believe your constituent may be having.
Thank you.
Can I just add to,
Sure.
When you complain against the judge, the committee that oversees that, they only meet once a month. So, depending on when you filed it, you could miss it. It's kind of disappointing, actually, that that's the case. And you have to bring forward, you have to provide all the proof as to, what the judge did wrong. I have a very big file and, that's putting the burden on me to submit everything that's already sitting in the courthouse.
Go ahead, Senator Carson.
Have you asked for an expedited hearing?
We just filed for an expedited motion.
Okay.
Yep. And that was, 10 days ago and still nothing.
Okay, you did have a sadder tale than I thought before. You remember we were talking about the people who went before you.
Yeah.
Tougher than I thought. Thank you very much.
Yeah, I told you this was not a good story either.
No.
Tough day.
Anyway, Senator, thank you very much. Anyone else in the room want to testify? Seeing none, that'll end the hearing on SP 414. Thank you.
Thank you. All right. We're not execing anything. Okay.
Tuesday.
Tuesday, okay. 414.
Motion to adjourn, Mr. Chairman?
Yep. So moved and you second. All in favor, say aye. Aye. I'm sorry.
What are we execing?
No, we were just ending the hearing.
Oh, okay. I was like, what are you doing? Thank you.
Just ending the day. Rights enforcement. Okay, these are.